Okay, so first part that we will draft now is the category of information that is being collected. Okay, it will depend on the commercial business model and the law, but I gave you the business model and I gave you the law. Okay, now just think of what are the categories that are being collected, because they have to inform their customers to take their consent. Okay, so I'm just helping you out with them. Your name, contact information is what it was taking, right? Name, address, email, contact numbers. Health and fitness related information it was taking. Usage data, indicating how you use the application. This is always taken. If you look at standard policies of Apple, Twitter, any app, okay, will track your usage data. And you need to inform them, otherwise you'll be in violation of the law. This is really important for apps to improve their services, sell more. Financial information is always collected. So they collect information related to card details, right? Transactional information. Now, financial information is your card detail, and transactional information is what? When did you purchase? Okay, two different things, right? One is your bank account detail or your card detail, and one is that when did you last make a purchase? When you draft the clause in a privacy policy, imagine yourself, now this is a drafting tip, okay? Imagine yourself talking to the customer. What does this mean? You will use a lot of I, you, we, okay? It's a direct talking. It's not drafted like an agreement. Okay, this party agrees that he or she shall do that. It's not like that. Okay, so I'm going to show you a model clause. Okay, don't try to memorize, don't do anything. Heading is simple: personal information that we collect. When you create an account on our website, we may collect a variety of information, including, think about it, contact information, give an example of it here, health and fitness related information. The next category is health and fitness related information. Okay, so try to type out these things. Okay, height, weight, fitness, exercise information. What else could be there? Think of more. Okay, this is how you will start to think how the app functions. Usage data about your activity and use of our offerings. Okay, these things need to be explained. You can't just stop at usage data. Financial information, data relating to salary, income, and assets information we collected. If they collect this, then they will say that we will use this. Otherwise, they'll say we'll only take your card details. Okay, transactional information is information about what product, what service you purchased and when. Okay, so this is basically the clause. If you go one by one, these are lines of the clause. Okay, usage data, these are bullet points and lines of the clause. Then draft a clause. This is now the second one. Did you follow the first one, how it said? Did you follow the I, we, you drafting that we will collect the following categories of data from you? Category 1, explanation. Category 2, explanation. Category 3, explanation. What your job is going to be is to identify from the app creator, your client, that what is exactly the data you will capture, because I am obliged to inform my client, every customer about this. Okay, that's the law. So you just have to identify these heads. Okay. Then draft a clause explaining how the data is going to be used. Remember, I showed you that section where it said that what data is collected, purpose for which it will be used, and whether it will be sold or shared. Okay. So California law requires how it will be used. Now, remember, these 5 purposes are usually standard, okay, in any privacy policy. To provide and improve our services. The data is collected for 2 or 3 things, okay? The app wants to improve their services. This is one. They want to communicate with you. They want to share new information, new offers. They want to collect your feedback. So this is another one. They want to process your transactions, like a payment transaction. So for which they want to capture your data, like they'll capture your credit card details. They want to comply with laws. If the laws require them to store certain data of yours, they will do that. This you must always add. Even if there's no law in the country requiring you to store data, tomorrow it may come, right? So you want to provide for that in your policy. Then security and fraud prevention purpose is a standard purpose that is listed out, because this is why people want to collect it. Okay. Now include a clarification. You must always do this, that it's not going to be sold if that's the case. Okay. If it's going to be sold, then you say you take the consent from the customer that this may be sold to so and so entity. Okay. Selling data and sharing data can be different things. Okay. Sharing is when you pass on the data without charging for that data. Okay. So here you can clarify that this company doesn't intend to sell data at the moment, right? They are only capturing for various purposes to improve their services and all of that. Okay. Mahafreen, what is the issue? Okay. Model clause, now I'll show you. So this is the heading, use of personal information. We will use your personal data only where we have a valid legal basis to do so. we may use your personal information for one or more of the following business and commercial purposes. Developing a personalized fitness regimen for you, covering exercise and diet. So this is the business part, right? For this is the purpose for which it is being used. So you're going to always ask the founders this, and you're going to say that, okay, if you change this, you need to amend it. Providing you with email alerts, event registrations and notices. Okay. Processing your transactions. This is how the clause looks. Okay. So if you look at it in a Word file, it will be one after another. These are the bullet points. To comply with applicable laws. Okay. If there are tax or reporting obligations, or to comply with a government request. To prevent fraud, including to prevent others for pre-screening or scanning uploaded content or illegal content. So they'll capture data to ensure that, okay, if there's illegal content uploaded, then I want to remove that, for which I need your data to identify who is uploading this. Okay. Next, write about which entities data is going to be shared with, because you remember they have integrations. They are going to allow Facebook to share your data. They are going to allow you to share your data with your friends, right? Now, you can't say that by sharing on Facebook, I gave the consent. You have to write it in the policy. The action is not okay to take consent. Okay. You have to tell them before. Even biometric information where you give under California law, what it says is, if I gave my biometric information without my consent being taken, then you can't use it. Okay. So you have to take separate consent for taking the biometric information, even if you've obtained it otherwise. Okay. Now let's get to the data sharing part. Which entities the data will be shared with. Okay. So simple clause, sharing of your data with third parties. We may share your personal data with third parties, such as service providers, trainers, delivery service providers, to provide our offerings fully. When we disclose the personal information, now one important thing is that if I'm going to share it with a service provider, and I am required to keep your data in a certain way, should I ensure that the service provider does the same? That will always be very important. Okay, because the responsibility for data protection is on you. So you take the consent and then that data is misused by a service provider, this will come back on you. Okay, any data protection law seeks that. So it says that when we disclose this data, we enter into a contract with the recipient. Whoever is getting this data has a contract with us, which requires them to keep this information confidential and not to use it for any purpose except for the services we are providing to you, or except for what we have written in the contract. Okay. Just try to hear and follow the logic. Don't try to memorize. Just follow the logic. Okay. Write about whether data will be transferred to other countries. So you understood here it is saying that data will be shared with third parties and with our employees or affiliates, but we will ensure that we have a contract with them so that they treat your data in a confidential manner and they only use it for the purpose that we specify. Then write about whether data will be transferred to other countries. There is no restriction, by the way, under California Consumer Privacy Act. GDPR of Europe has this restriction on when you can transfer data outside Europe. Okay. But here it's not there under CCPA. But what do you need to do? See, if the data protection gets compromised, then the California company becomes liable. Okay. Exporting data is not a problem. Transferring it, storing it on a Bangalore server is not a problem. Okay. Or in a Nairobi server is not a problem, but it needs to be treated the same way. Okay. So what do? You say that we'll give you California level protection. So one way is this: data transfers to other countries. This is the heading. Okay. Now we do this. We have arrangements with third-party service providers who may process your data to give us insights on how to customize and improve our services to you. Or for instance, to develop appropriate training regimens for people of specific origin. So in America, in California, you may have people with different ethnic histories, people from different origins, right? So we want to share data with external people outside the borders of US. Okay, where we share personal data with our affiliates and third parties outside US, it will continue to receive adequate protection through contractual arrangements put in place. Okay, and that includes the clauses that give personal data equal protection as in California. Okay, the last one. We're teaching you 5 important clauses. These are the most important clauses of any privacy policy. Okay, last one is writing about the customer's right to know. So this is there in a lot of laws. California Consumer Privacy Act has it. The GDPR of European Union has it. The Indian data protection bill will have it. Okay, so you have to write about the customer's right to know what data is collected and to have it deleted. Okay, which means that they will specifically ask you, that a customer can ask you on a particular email ID or through a form, tell me what data of mine is collected, and then delete it. And that you have to inform them through the policy. This is the section 1798.105. Okay. So you can read it through the act. This is one way to read it. Provides a right to the consumers to request that the business deletes any personal information which has been collected. So what's a model clause for it? So you see, you're doing the drafting, but you're measuring the law side by side. Okay. So this is a simple way to draft it. How can you exercise your rights under CCPA? Under the CCPA, you can just say this. Under the California Consumer Privacy Act, you write the full form. You have the right to access personal information that we have collected about you during past 12 months and information about our data practices. You can also request that we delete the personal information that we have collected from you. In order to access, manage, or delete your personal information, please contact us through this form, which is the California, and you can give a link. Okay. And what these big websites do, because this is a unique law to California, right? If you look at Twitter, you look at other companies, Facebook, for example, they have a separate California privacy notice inquiry form. Twitter has made the whole global privacy center, because privacy laws of different countries vary a little for that purpose. Okay. Few more clauses are required to complete the privacy policy.